This matter came up for mention to confirm compliance with the orders issued by this court on the 24th day June 2026. On that date, this court found the respondents' contemnants to be in contempt of the court orders. Upon hearing the parties, the contemnants sought indulgence from the court and represented that they will release Kenyan shillings 7 million to the decree holder within 2 days. The court consequently granted them an opportunity to purge the contempt by complying with their own proposal. The court further directed that the decree of balance be paid in accordance with the resolution and the proposals to emanate from the governing council, and that the said information be presented to the court on today's date. When the matter was called out today, counsel for the decree holder submitted that none of the undertakings made before the court have been honored. It was its position that the Kenyan shilling 7 million has not been released. No proposal regarding settlement of the decree of balance has been presented, and no compliance whatsoever has been demonstrated. Counsel urged the court to issue warrants of arrest against the contemnants and direct that the same be executed by the OCS Kisii police station. Counsel further submitted that continued disobedience of the court orders undermines the authority and the dignity of the court and ought not to be encouraged. On his part, the learned counsel for the respondent submitted that he duly advised his client on the consequences of non-compliance with the court orders. Counsel stated that the chairperson of the council works at Murang'a University and had allegedly authorized the principal to facilitate payment. However, according to the council, the principal has neither acted upon nor facilitated payment or excused the. However, according to the council, the principal has neither acted upon nor executed the said authorization. Counsel candidly informed the courts that he has done his part as an advocate and has no further information from his clients regarding compliance. I have considered the record of the court as well as the submissions by both counsels. The issue for determination is whether the court should issue warrants of arrest against the contemnants for their continued disobedience of the court's orders. The record is clear that respondents were found to be in contempt on the 24th day, June 2026. They were granted an opportunity to purge the contempt and were given specific timelines within which to comply. The orders issued by the court were neither stayed, reviewed, nor set aside. To date, there is no evidence that any part of those orders has been complied with. In Atkinson versus Atkinson, 1952, a decision that has consistently been cited with approval by the Kenyan courts, it was held that it is the plain and unqualified obligation of every person against whom an order is made by a court of competent jurisdiction to obey it unless and until it is discharged. A party cannot choose which court orders to obey and which ones to disregard. Similarly, in Econet Wireless Kenya Limited, Minister for Information and Communication of Kenya and another, 2005, the court emphasized that the rule of law requires that the court orders be obeyed and that the court will not condone deliberate disobedience of its orders. The court observed that it is essential for the maintenance of the rule of law and the authority of the courts that court orders are complied with at all times. The explanations advanced before this court do not amount to compliance. Internal administrative challenges, communication lapses, or failure by third parties to act on instructions cannot be invoked as a justification for disobedience valid court orders. The contemnants were granted an opportunity to comply with orders they themselves proposed. They have not demonstrated any effort towards compliance and have not even deemed it fit to communicate with their counsel or seek for further directions from the court. This court cannot remain a passive spectator where its orders are openly disregarded. The authority of the court and the administration of justice demand that court orders be obeyed. Failure to enforce compliance will not only prejudice the decree holder, but will also erode public confidence in the judicial process. Accordingly, I am satisfied that the sufficient grounds exist for the issuance of the warrants and orders as follows. That warrants of arrest are hereby issued against the contemners, judgment debtors, for continued disobedience of the orders of this court issued on the 24th day, June 2026. For avoidance of doubt, Geoffrey Andama, Principal, Kisii National Polytechnic, and Santino Ojaro, Chairman of the Governing Council, Kenya National Polytechnic. B, that the warrant shall be executed by the OCS Kisii Police Station or another police officer acting upon his authority. C, upon arrest, the contemnor shall be produced before this court on the earliest available date for further orders and directions. And the costs occasioned by today's proceedings shall be borne by the contemners. It is so ordered.